Still with me is criminal defense attorney and former prosecutor David Bruno. And David, I want you first to explain to our audience this whole concept of 404B and what exactly is being claimed here by Paschel and why it's so important and why it's such an important issue for the courts.
Yeah, sure, absolutely. When a defendant is charged with a crime, the jury should assess their guilt or innocence on the crime itself. We should not be bringing in bad act evidence or propensity evidence, meaning that, oh, this defendant's bad. This defendant has done things in the past. This defendant has a record. No, they should be judging the defendant's guilt or innocence on the facts in the indictment itself. Now, the exception to the rule of prohibition is this rule 404B that the defense attorney cites. And that is, there are certain circumstances where it's material, where it's so similar that it shows probative value, it has probative value. But there has to be a pretrial hearing outside the jury so that a judge could determine that it meets the criteria to be admitted as evidence. Because otherwise, it shouldn't go in front of the jury. The jury should make the decision based on the act itself. Here, what the defendant is saying is that without any notice, in the middle of trial, the alleged victim produces new information not known to the defendant at the time that strikes upon this bad act evidence that shouldn't have been admissible. And the defense is saying that they should have got a hearing. I'll tell you what, they should have gotten a hearing. Yeah. They absolutely should have gotten a hearing, and the hearing should have happened prior to the trial. If I were the judge, I would have excluded it. It's late, there's no notice, and at the very least, the judge should have had a hearing. Absolutely. So the question is going to be, really, I think the appellate court in this motion for a new trial is going to go into the substance of the allegation and do a balancing test now, because it's much stronger for the defendant if that evidence should not have come in. If it's just an issue of a procedural argument that they should have had a hearing and ultimately the court would have admitted it anyway if they had the hearing, it's not going to be as strong as if the court would have precluded the evidence. That way, bad evidence, bad character evidence, propensity evidence came into the jury without it being proper. And that would be the best argument that the defendant has for a new trial, and also will also be appealed up at the appellate division in the event that they're not successful here. Yeah, and actually, to be clear, this isn't the appeal level. This is sort of within that post-trial relief where they're just asking the same judge in the same court to say, hey, take a look at your ruling here. This is problematic for us, correct? Yeah, right. That's a tough argument to make before the same judge, where a judge is going to say, yeah, I made a mistake and I'm going to reverse this conviction. I think what the judge will do is it'll do the balancing test now and say, so it's protecting the record and say, well, if I did the balancing test, then I would have admitted it anyway. And then the defendant would be left with the procedural issue. But in any event, I don't think that this is going to be reversed right here before that same judge. Like you said, Michael, they're going to have the same argument on appeal. And I will say to the viewers, it's one of the strongest arguments on appeal for defendants. Absolutely. There's usually two of them that's the strongest. On jury instructions, where the jury did not get the law properly, and bad act evidence or propensity evidence that was admitted improperly. Yeah, and it all goes to that. The two most appealed issues that lead to reversals. Absolutely, and it all goes to something we take very seriously in our criminal justice system, and that's due process. And really, he was denied that here on a number of levels. So we'll have to see how it all plays out. And I agree. I think they're not going to make it here, but then it will be appealed, and I think he might have some issues there as well. All right, David, stand by.